Hello, everyone, and welcome to our Chapter 9 start recording. I wanted to get us started with Chapter 9 a little bit early, just so at least we can get ahead of the game. I know that, like I said, I wanted to get us further along, so at least we have more time for review when we get closer to May for you guys. So I just wanted to get started. I did tell you guys before we went on this semi-break that we would probably have a recording of some sort to get you guys, ready to move on with the next chapter and continuing with the unit. All right, so that's what we're doing right now. Okay, so let's just get started. I'm not gonna go through too much today. I just wanted to give you guys kind of a basis, so at least when we enter school tomorrow, you guys are all set and ready to roll. Okay, so the next chapter 9, civil rights. So if you're looking at the Wilson textbook, which is the one that we use for our course, I think this is chapter 6 in their textbook. So if you're using the iBooks link, it should say chapter 6 is civil rights. So as long as it has the same title, that's what we're covering. Because all the chapters from this book, and we use the Abernathy. These are what the Abernathy textbook company uses, these PowerPoints, but basically they cover the same exact content. Just like I said before, Wilson's a little bit more in depth. So that's why we're using the same content. It's really just the textbook. Wilson textbooks is more of a college level reading. This one still covers the AP material. It's just more, I think, a little easier to read. So that's why I chose this textbook for you guys. But if you're going to read the textbook, it is supposed to be chapter 6, civil rights. Okay. So we're going to start with chapter 9 with securing the rights for those with disabilities, because we'll get into more basically the whole concept of civil rights, not just with African Americans, but with many other groups as well, including women and those with disabilities. So firstly, civil rights. It's not the same as civil liberties. Understand there is a difference between the two. So civil rights, if you're looking at definition, is protections for individuals from discrimination based on race, national origin, religion, sex, and other characteristics that basically make sure that they are treated equally under the law. Civil liberties is a little different because it's just protections from the government. That's why all the cases that we focused on so far, well, all instances where the government, whether it's state government or federal government, was breaking a specific Bill of Right or even another amendment that was infringing on the rights of the individual, right? Civil rights is now becoming more about the protection of individuals from discrimination, right? So it's a little bit more specific to a certain field. Okay, so when it comes to those with disabilities, what the big law that it was passed with the Americans with Disabilities Act in 1990, this had basically prohibited discrimination of employment, buying goods and services, and also participating in government programs. As in, they could not be not hired or not allowed to buy a good based on their disability, which is a big step forward. And now, based on a lot of these laws, that public facilities must accommodate for individuals with physical disabilities as well. All right, and there were a lot of sit-ins and rallies that kind of jump-started this process, but it also started a lot earlier than the 1990s. But obviously, the Americans with Disabilities Act had basically made it almost commonplace, no matter where they were, that this was a secured right that those people with disabilities have. And this is a picture in April of 1977 of the 504 sit-in that was live televised and made public for everyone to see. Okay, so the big question for this section is, how does the Americans with Disabilities Act illustrate tensions between civil rights and federalism? So I'll give you a second to think about that, right? But just think of this. Civil rights, not even just the Disabilities Act, right? But the two concepts here is going to be civil rights versus federalism, right? Remember, federalism is the idea where the states can decide. If the federal government isn't covering something, the states can decide the rest of it, right? Remember, we talked about the federal government has these broad concepts, and then the state government has the details. So the idea where now specifics, the idea where the federal government gives you an outline, like a big concept, and now the states have to decide what happens with it. And you're going to see this aspect, civil rights versus federalism, happen throughout this chapter. Now, specifically, when you look of the Americans with Disabilities Act gives you a specific example, but we'll jump into with more racial lines. We'll talk about even for women. These are all going to be the same battle between civil rights and federalism for each and every one. So we'll talk more about it in class, about the tensions themselves, but obviously there's going to be a problem, right? There's going to be an issue between what line can the states cross and what line they cannot cross, okay? So here's a free response question. I will definitely use these for a quiz or test, so be prepared to answer them. These go along with each one of the PowerPoints, so like I said, be prepared. All right, so now we look at segregation, okay? So there is a lot of cases leading into segregation, okay? So firstly, the Dred Scott versus Stanford case in 1857. This was kind of the start of pure segregation. Remember, the Supreme Court, this is from U.S. history, Supreme Court ruled that slaves were not citizens, that even if you lived in a free state, it didn't matter, or a free state or territory, it did not matter. As in, it ruled the whole concept that you can label a free state or a slave state to be basically is unconstitutional. So this caused a lot of issues, and it basically had set the stage for what the Civil War was really about. All right, but obviously with the Emancipation Proclamation, this had changed the whole concept of war. Remember, if you guys had in U.S. history, we didn't really get to cover the Civil War, but understand the Emancipation Proclamation was almost like a military strategy. Think of it this way: Abe Lincoln was trying to secure the Union, so he had a choice, and he asked the southern states, like, listen, I'll allow slavery to continue for a period of time until you guys can really understand like how to live life without slaves, as long as you join back the Union. But the southern slave states said, no, we're not going to do that. We want to keep slavery no matter what. And he says, okay, fine, then you get nothing. So he did the Emancipation Proclamation, and basically his mindset is that if you get rid of the one thing, well, probably one of the biggest things they're fighting for, a lot of the troops of the South, the Confederate Army, are fighting for to keep their slaves. If you get rid of that concept, then they will give in, because that means they're fighting for nothing else, okay? So the Emancipation Proclamation was basically a war strategy, and it technically ended slavery within the United States for good, all right? And obviously after the Civil War had ended, it was really where we started to see more of the transitional amendments that have officially ended it. So in order to keep control of and restrict freedmen from rights, the southern states created the Black Codes, which has restricted them even more, and created them basically to limit them from growing any further. But the amendments, these three, basically considered the Civil Rights Amendments for African Americans, were created to make sure that their rights were protected. So the 13th Amendment, prohibited slavery. 14th Amendment, which is crucial because it is used for many different concepts, all right? Remember, the 14th Amendment's always used for every time that there is a state issue. The 14th Amendment is always referenced as a counter to what the state says in regards to the federal government's law, right? And we've seen this with many different cases. We've seen it with Chicago v. McDonald. We saw it with a lot of the criminal procedure cases. We saw it with a lot of the freedom of expression, freedom of religion cases. Each one of them was made alongside, whenever they said, oh, you're breaking the First Amendment freedom of the exercise clause, they used the 14th Amendment as well. So each one of these goes alongside with that. But it was originally created to stop slavery and stop African Americans from being limited, right? Because it basically was trying to say that they have the right to same due process on the laws as every citizen, and also made sure that those that were born citizens, that if you have a citizenship, even if you were born a citizen, you have the same right as every other American citizen in the United States. All right, and this was to protect the freedmen and also those that were born as slaves in the United States, that they would automatically gain citizenship. All right. The 15th Amendment is straightforward. It gives granted the right to vote for male African Americans. Obviously, there's that line that says male African Americans, because obviously the right to vote for women did come later on. But we did still see there was a a problem what was going on in the South, as in they were finding loopholes in the system to make sure to still attempt to during the Reconstruction era to limit the amount of that African Americans had freedoms. Okay, and we saw this in all different ways. When it came to transportation, we saw it to entertainment, like movie theaters, or even in bars, businesses, and education. Specifically, most importantly, voter suppression, and we've seen a bunch of different things. Remember that they used to create these different laws that said that if your grandfather was not a citizen of the United States, then you will have to pay a poll tax, or you would have to take a literacy test, right? And these literacy tests were literally, like, not trying to make a joke there, literally impossible, right? And I'll let you guys be able to practice one. I have one here for you guys just to take a look at. They have the literacy test, and what I did for my class last year, I let them try their best to try to answer these questions, because the bottom line is you have 10 minutes to complete the test and get every question correct. All right, and this is Louisiana, right? This is a famous one for Louisiana, that it's supposed to say you have to prove you have a 5th grade education to do this. Now, each one of these questions is extremely complicated, and the point is that even if you were able to complete this entire test in 10 minutes, it's 10. So there's how many questions? 30 questions in 10 minutes. Let's just say you were able to do that. Each question has a multiple ways to answer it. So they would find the way that you answered it and say, no, you were incorrect. It's supposed to be answered this way. So it doesn't matter if you even completed this correctly, technically, they would find a way to say that you were incorrect. And during that time, especially, most people did not have, especially African Americans, did not have the education. So even if they were smart enough, let's just say they were a northern freedman that had gotten education and moved to the South and was trying to vote, and they had education, and they answered the test in 10 minutes, they were probably most likely unable to pass it because they would find a way to fail them anyway. So these were all things they tried to get them to fail and not be able to vote. Now, the Plessy versus Ferguson case, even though it may not be a foundational document, you should definitely know it. All right, but it created the separate but equal statute. Right, Homer Plessy was 7/8 Caucasian. Okay. And he was arrested and fined for violating the state law that required those that were African Americans to have to sit in a separate rail car. Right, the court ruled that he did not violate the 14th Amendment and stated that facilities can be separate as long as they are equal, as long as they function and do the equal, are equal in the way, like, let's just say if you're like most famously the water fountains, right? If they have 2 water fountains, one they both work, right, but one is more poor conditions, but the bottom line is they both work. That means it's okay because they can be separate. This can be the black water fountain, this could be the white water fountain, and obviously if they both work, then it's okay. Even though it's clear as day there is a separation, they said it's okay to have separate as long as they are equal. Right, and this had remained for many years, generally around 60 years, this remained. And we started to see a sense of legal segregation, as in a way that they were able to get around the law to make sure that they were still segregated and it was allowed. Right, and we started to see that for many years, especially when it came to within public schools, and in other facets, especially in private industries as well. And this started to happen for a long time. Now, the NAACP had led a charge to try to go after those, especially specifically schools that were segregated, and to use it as a way of saying that they're violating the 14th Amendment that was going on in a lot of these school buildings. And they kind of set the stage for probably one of the biggest court cases in AP government, which is going to be Brown versus Board of Education. So for this final part, I wanted to kind of just get through a little bit and set the stage for you guys for Brown v. Board of Ed, as I want you to look at this image, okay? So I'll read the opening for you. Although admitted to the University of Oklahoma Graduate School, George McLaurin was made to sit at a desk by himself outside of the regular classroom in a library. He was assigned a segregated desk behind half a carload of newspapers. McLaurin challenged his separate treatment of the University of Oklahoma and won his case. Now, even if this is the case, right? Even though this is the situation, he won his case. This is still different. As you can tell by this image, he is here. The rest of the class is in the room. And obviously there is a wall. They had an opening here. This is the wall. So he is sitting outside, technically, the classroom, and he has to look into the classroom while being in a lecture class. So there's 3 different things you need to do for this. Number 1, explain how Thurgood Marshall could have used the photo to support a sociological argument about the intangible effects of segregation. Number 2, based on the photo, describe an argument the University of Oklahoma might have made that the segregation did not violate the Equal Clause protection. And number 3, identify at least one other type of discrimination that is evident in the photo. All right, so you're going to use this image to answer the questions. That's going to be the one thing I want you guys to do other than watch the PowerPoint for tomorrow's class, because tomorrow we're going to focus on Brown v. Board of Ed, which is, like I said, a major key case that is essential for AP Government and Politics. So I'll leave you guys be excited for that one, and we will get onto that tomorrow in class.